Dimitri, from your perspective, you spent a lot of years as a prosecutor, now as a defense attorney. In looking at possible scenarios here, would there be any downside for the prosecution to say, all right, we know that Sarah Kaplan is not going to testify. We know that she needs to spend a day in jail or so for the judge to declare her unavailable. So we will agree to stipulate that, yes, she's not going to testify, she will be unavailable, and as a consequence, we'll eliminate the necessity of her having to spend a day or two in jail. Is there any downside for the prosecutors to go ahead and do that?
As a prosecutor, when you have powerful evidence such as coroner testimony or other powerful crime scene testimony, you want to have a live witness there to present that. I think there's more convincing force from testimony from an actual live witness. Here, you would have a former defense lawyer who arguably doesn't have any motive here to try to pin something false on her client or twist the testimony in a way that's negative to her client, that's stating one of their own defense criminalists. Dr. Lee recovered evidence and it's no longer around. It's either been destroyed or discarded somehow. So if I was a prosecutor in Mr. Jackson's shoes, I would want to present a live witness. I would want Ms. Kaplan to testify because I believe there's more compelling force to that evidence, to that type of testimony.
And I think that makes a lot of sense. Let's take it the next step. If indeed, however, the prosecutors are convinced that she's not. In other words, she came with her bag packed today and ready to say once again, I'm sorry, I can't testify here because of my relationship as a former defense counsel, so if you have to put me in jail, okay, send me in jail. And if prosecutors know that the judge will do it for a couple of days and then say she's unavailable, is there any downside to them for handling it in that fashion? Say, okay, we don't want to see her go to jail. Let's agree that she's not going to testify, and we'll go ahead and read her testimony to the jury.
Yeah, I mean, ultimately, if she refuses to testify, then I don't see why the prosecutors can't just stipulate to her unavailability. The problem is, for stipulation to be valid, you need two sides to stipulate. And so you need Mr. Spector's, the defense side, to stipulate to her unavailability. Otherwise, the stipulation is no good. It has to be a bilateral type of agreement. That's what a stipulation is. It's an agreement that she's unavailable. If Phil Spector refuses to enter that stipulation, it doesn't matter what the prosecutors do or do not want. The bottom line is there will not be a stipulation at that point, and the judge must find her unavailable at that point. Additionally, there's an issue of appellate rights for Mr. Spector. If he does stipulate to certain issues and certain facts, does he give up certain rights on his appeal? In other words, if he is ultimately convicted and does appeal the conviction, if he stipulates to Ms. Kaplan's unavailability or in any way concedes that, does he lose that appellate issue to fight the conviction on appeal? Does he give up an issue that he would otherwise have?
So it's a significant chess game going on inside of that courtroom then, Dimitri, yes?
Yes, absolutely. I think both sides are, a lot of the circumstantial evidence coming out could help the defense. It could help the prosecution, and people are maneuvering in a way to make their case the strongest. And ultimately, for the prosecutors, if it is a tie, they lose. They cannot have any reasonable doubt to get a conviction in this case. They have to get rid of any reasonable doubt. So it is a chess game, and it is a chess game for both sides. And for the prosecutors, if it is a tie, they lose.